I'm alive. I have a new phone. So hopefully my videos will be better, clearer. And I have been trying to wrap my head around this New York Times stuff. A lot of people have asked what I think. Why do I think the Wayfarer parties didn't take up Judge Liman on the offer to explain why judgment should not be final? And it's actually pretty complicated, all of the things that are going on. And there are a lot of maybes of why something is happening. And without really knowing what's going on behind the scenes, it's pretty difficult to speculate. So I have come up with my best speculation as to why things are happening the way they are. But let's recap. So the June 9th order dismissed the New York Times from the lawsuit that Wayfarer had filed against the New York Times and Lively and Reynolds, etc., etc. And then on September 12th, the New York Times moved for entry of judgment under Rule 54B, essentially asking for the final judgment on behalf of the New York Times. And the judge came back on October 17th and said, these are the requirements to have a final judgment. Explain to me why I shouldn't enter it. And the Wayfarer parties didn't oppose, didn't file anything. Lively came and said, these are reasons that we think it should be final, which is not what the judge asked for, but they did it anyways. And the Wayfarer parties didn't file anything. It should be noted that they didn't file anything in response to the New York Times motion, September 12th motion to begin with. And then when the judge offered another opportunity for them to provide a reason why final judgment shouldn't be entered, they didn't file anything, which suggests that they had no real opposition to entry of final judgment. So the question is why? Well, there's a couple of things going on. So there was a late September, early October filing by the New York Times in New York State Court, filing an anti-SLAPP lawsuit against Wayfarer, saying essentially that you were not allowed to sue us for the thing that you sued us for under these anti-SLAPP laws. So anti-SLAPP sounds very confusing, but SLAPP is actually an acronym. It stands for Strategic Lawsuits Against Public Participation, which is essentially lawsuits that are trying to prevent First Amendment exercise. So anti-SLAPP laws allow defendants in those lawsuits to recover their fees and costs and having to defend themselves against those particular type of lawsuits. So it's, in some ways, you can think of it as operating in a similar way to this new California 47.1, although California also has anti-SLAPP statutes, but it's specifically with respect to the exercise of strategic lawsuits that are brought to cull First Amendment participation. There's another famous lawsuit, actually, that involves the New York anti-SLAPP law, and that's Kesha and the Dr. Luke lawsuit. And remember, that's the lawsuit where the alleged abuser, Dr. Luke, filed a defamation lawsuit against Kesha. And in that case, Kesha tried to use this anti-SLAPP lawsuit to say that your Dr. Luke lawsuit, defamation lawsuit from me, is a strategic lawsuit that is intended to inhibit my First Amendment rights to be able to speak freely about what had happened to me. And in her instance, the law amended in the middle of all of the proceedings. And so an appellate court ruled that it doesn't apply retroactively for her to be able to recover her fees. If anyone is interested in a deep dive on that case, drop like a, sparkle emoji or something down below and I will look into it more. I was just sort of reading over it as I was digging into this New York anti-SLAPP law. Anyway, we've strayed too far. So now the New York Times has filed this lawsuit against Wayfarer in New York State Court under the anti-SLAPP laws, saying that you, Wayfarer, owe us $150,000 for all the fees and costs that are associated with us having to defend the lawsuit that you brought against us. And that was wrong. You shouldn't have done that. And so you owe us this money. And what I find interesting about that is that, well, $150,000 is a drop in the bucket for someone that's paying the types of attorney's fees that Wayfarer is paying. So it just seems odd that they wouldn't have just tried to resolve that outside of court. So it seems to me that it was strategic for them to file it, and it was potentially a message to anyone that tried to challenge the New York Times on similar grounds. So a message to people to say, we are not to be messed with, and we will make sure that you litigate this, and it will cost you way more than $150,000 to deal with if you do this. So I think it was a message by the New York Times to anyone and everyone that tries to do this against them. And so the New York Times wants final judgment in the federal lawsuit so they can go and pursue what they need to pursue with respect to the anti-SLAPP, and it would be evidence for them that this is final and done with in the federal court, and therefore want to fight on the grounds that it's done there, so there's nothing to wait for. Now, Wayfarer did not respond, as I mentioned before, and they did bring on these appellate lawyers. And it's possible that they are considering what an appeal might look like with respect to a final judgment against the New York Times. Now, a separate video would be required as to speculating what that might be, but that might be one reason why they didn't challenge the request for a final judgment. In any case, eventually they were going to get New York Times was going to get a final judgment. And so it almost seemed like a meritless fight, just to fight for the sake of fighting. It wouldn't get them very far because eventually the New York Times would get that final judgment. And now there's this anti-SLAPP motion or lawsuit in New York State Court. And so if there was an appeal of the order, the June 9th order with respect to the New York Times, arguably that would require a stay in the state court. And a stay is when it's basically like a big pause button. So if there's an appeal going on with respect to the June 9th order and the federal appellate courts have to deal with that would be the Second Circuit, then the state court would be inclined not to continue with the anti-SLAPP litigation because there's a question of whether or not the order that was made final in the federal court that's now being challenged in the state court is actually valid. So it might be some kind of play there to people leveraging against people, basically. Is any of this making sense? Am I just confusing people? I was talking to not actually Golden and Britt over the weekend about this, and we were kind of shooting in the dark, trying to figure this out. And something that I thought about and I shared with them is that I wondered if the New York Times filing this state court anti-SLAPP lawsuit was actually a tell. And they might be a little bit worried about what evidence has been uncovered in the underlying lawsuit, in the Lively lawsuit, that implicates them. And I do think that it goes back to the Van Zandt subpoena. Because if, for example, there is evidence that somebody inside of the New York Times knew or directed Lively to do what they did, or something similar or something related, that's a really bad look and could cause bigger problems for the New York Times. And so by filing this and getting the timelines going on some of the other stuff, they're pressing the gas pedal and putting pressure on the Wayfarer parties so that they don't have to deal with this other issue if it comes out. They're getting ahead of it. That's my current suspicion, and speculation and more information could change my mind on that.